Welcome to the IEA's 37th webinar of 2025. Today we'll be discussing a study or sharing some insights from an analysis that we've done on applying cost effectiveness analysis to address Kenya's case backlog crisis. So my name is Jacqueline Kagume, and on behalf of the IEA, I welcome you to participate in the discussion, contribute, and share your views on what we'll be discussing here. And just for a brief background, the IEA is a public policy think tank, and our mission is to advance informed policymaking through evidence generation, policy analysis, and convening informed dialogues. We work across 6 policy areas, beginning with the public finance management, constitution, law, and the economy, which is the program that is hosting our discussion this morning, where I work together with my colleague Leo Kemboy. And then we have a program on economic regulation and competition policy, another one on futures and foresight, international trade and development, and the last program is on popular economics. So as I've mentioned, our discussion here is convened by the CLE program. And our approach or our goal is usually to apply legal and economic analysis to various policy choices. As part of that work, we normally monitor the work and the performance of different institutions that are created by Kenya's constitution. Of interest to us has been the judiciary, that we've done quite a bit of work over the last couple of years, basically trying to study what approaches can lead to more effective and efficient administration of justice as listed or as described in the Constitution, from budget policy analysis to political analysis of understanding the resource allocation to the institution. So over time, we've studied a number of things around the performance of the Kenya judiciary. So today's, as you can see from the title of our discussion, most recently we've done a study on applying one of the economic tools to try and resolve the case backlog crisis, and that's the cost effectiveness analysis. So that's in terms of a brief background. I see we're already on the outline, but so in terms of the outline, so we'll begin by framing the case backlog crisis, which most of you already know the extent of the problem. So what it looks like in Kenya today and why it continues to grow despite the efforts to reduce it. And then we'll unpack the cost effectiveness analysis as a policy tool. So basically, briefly going through what it is and how it differs from cost benefit analysis and why it's particularly suitable in justice sector planning. And then we'll connect this remark to the policy problem, so facing the judiciary, so particularly around resource allocation, staffing, and efficiency. So basically seeing how the CEA or cost effectiveness analysis can be applied to resolve the policy problem. And our ultimate goal here is basically to show how the CEA as a tool can help policymakers, Parliament in particular, to make informed, evidence-based budgetary decisions when it comes to allocating resources to the judiciary, that's in a way that can strengthen access to justice and uphold the constitutional guarantees. So that's it in terms of the outline. We'll be making this presentation, as I already mentioned, together with my colleagues. So I'll just cover the background briefly, and then Leo will come in and talk about the policy problem and just see the results of our analysis. So in terms of the background, looking at the dimensions of the case backlog problem. So I think obviously all of you here already know that the issue of case backlog, or which translates to delayed justice, has been a serious challenge in our judiciary. So, and this has been in spite of different reforms. We've seen previous chief justices coming up with their own strategic direction of how they can improve the effectiveness of the judiciary, their own strategic papers. The judiciary itself obviously has its own strategic plan, and despite all the efforts, the case backlog problem remains unresolved. So in studying this problem, we tried to look at the different dimensions of the problem, how it manifests. And so we came up with what is a sort of a five-dimensional approach, which is like a pentagon view to understanding the problem, because there are five dimensions to it. So the first is, and the obvious one, is that we have a high volume of unresolved cases. And here, we know that thousands of Kenyans are been waiting, or are usually waiting for several years to be able to have justice delivered to them in whatever form that they seek. So the high volume of unresolved cases, this is illustrated annually. You can check the state of justice report, the SOJA reports. So we see that high volume. And then the second, we see that case filings continue to rise. So on the one hand, the previous ones remain unresolved. Then the number of case filings also continue to rise, which signals that the system is under strain. And the inflow of cases, despite pending cases, is obviously outpacing the judiciary's ability to resolve them in a timely and efficient manner. So that's the second angle of the second dimension of the backlog crisis. And then the third is that the funding and staffing levels have not kept up with this increase. So as more people seem to seek justice, the system's capacity remains apparently, I would say, almost stagnant. So true, there has been a marginal increase in the allocations to the judiciary over the last couple of years. But even with that marginal increase, it does not match the growth in the demand for justice, for access to justice. So as people are seeking interpretation of the court on different matters, filing cases, so the demand for court services does not match the increase that we have seen. So that's on the third thing. Then fourth, these delays have real human and institutional consequences. So we know that prolonged economic disputes, prolonged lack of access to resolution, proper resolution on, say, a contractual matter, there are serious consequences, both economic, human consequences, and we have seen some drastic results as well, where people have had unresolved cases relating to land. So even the question of the right to life. So we have seen the implications even for rights provision and provision of public goods. So there are real human consequences to the issue of non-resolved cases. And then finally, the last issue is improvements exist, but these are insufficient given the scale of the structural issues. So what you're saying is, like, despite the improvements that we've seen on different elements. So both in terms of the performance of the judiciary, the e-filing, the attempt to digitize the systems, automate most of the systems, the attempt, as I've said already, to add a few resources to enhance their performance. These have not been tied adequately to the demand. And so that's why we see the problem continuing to pile up. So these have been too fragmented. And so basically they are unable to, the changes that have been there are unable to solve the structural issues that have driven the backlog crisis to what it is today. So that's it in terms of this slide. The next thing that we see, so after we understood the dimensions of the backlog crisis, we looked at the numbers, so to give us a clearer picture of the problem. And so as you can see here, the volume of the pending cases has been rising steadily over the last few years. So, and that's obviously despite the reforms that I've spoken about. So we see more cases being filed each year than those that are being concluded. So the only slight difference was decline was between the financial year 2021 and 2022. So there was a decline there, which perhaps could be attributed, that was the period around the COVID. So I would suspect that because the lack of physical meetings at that time before the translating to the move to the transition to the digital system fully, I think there was a period there where the limited interactions could have meant or translated to limited filing of cases. So that, which is why we so that slight decline, but then after that, the numbers seemed to move right up again. So you can see there the numbers speak for themselves, and you can see the trend line. So then we move to the next question, which is on now applying cost effectiveness analysis as a tool to various to making certain policy decisions. So CEA in policy. So what exactly is cost effectiveness analysis, or CEA, for those of you who may not be aware? As defined in our studies, so we came across work by Kaplan, and basically CEA compares the costs of two or more actions with their outcomes. So cost effectiveness, as you can see, the word is effectiveness. It's trying to measure the effectiveness of a specific policy direction or policy proposal as opposed to another. So not necessarily in terms of the monetary terms, but in terms of the measurable results. So in this case, the outcome here is the number of could be the number of cases resolved from the way we applied this tool for our study. So unlike the cost benefit analysis, for those of you who've interacted with the different economic analysis tools, so the CBA tries to put a shilling value or a dollar value on the benefits of policy. So so to put, in this case, would be to put a shilling value on the benefits of or access to justice. But if you use the CEA approach, which is the cost effectiveness approach, we would not be trying to attempt to monetize justice per se, but instead to focus on the cost per unit of output. So, for example, the cost per case resolved across different interventions. So this makes it an ideal tool for public policy sectors, or just trying to understand public policy decisions where benefits are often social or and intangible. I've previously referred to the implications, the human implications of lack of access to justice or the cost of ineffective resolution of cases. So the cost effectiveness analysis tool helps policymakers in concrete terms to understand what would be the effectiveness of a specific approach in deriving the certain outcomes or in deriving specific outputs. So in this case, if you're by applying the CEA, policymakers and parliament, for instance, can see which investments would produce or how the applying certain resources would produce the greatest impact. So for instance, is it by hiring more magistrates? Is it by digitizing case management? Is it by expanding the court infrastructure? That's the physical court infrastructure. So what would be the most effective mechanism to have effective results given the functions of the courts? So ultimately, this approach is supposed to, and I had mentioned this before, is supposed to allow the judiciary and parliament to make better budget decisions that are efficient, that are transparent, and that are aligned with the constitutional principle that justice shall not be delayed. So that's it for that slide. We go to the policy problem. And at this point, I'll invite my colleague Leo to go on with the presentation. So Leo, please take it away.
Yes, thank you, Jackie. And so as Jackie has explained, they are the 5-dimensional questions. But given the fact that we've studied this problem of case backlogs and the resource political economy of resource allocation in the judiciary, we've also studied the cost. We've costed estimates of what should the consumer mandate of the judiciary be like, and in terms of budget outlines, what would that look like? We've done a synthesis of almost like 7 studies, and one of the things, there are many key things that we've learned, and we'll provide a short rendition for you to appreciate the sense of the problem that it is. So a larger part is the judiciary has a backlog crisis, but again, that backlog crisis is also tied to the courts of first instance. So as you all know, from the way the court system works in Kenya is you start from the magistrate, matters are filed first at the magistrate, and then it goes to the High Court, and then it goes to the Court of Appeal, and then the Supreme Court. Some other matters start from the High Court, like the questions of constitutional review and others. So where you see the bigger burden is at a lower court level. Then the second question is the Parliament's budgetary framework. The way they've approached the question is that they've given it on a they've grown the budget slightly more on a year-by-year basis. And we think that if you have a constitutional imperative, and also which is a public good, court access is a public good, and that has an implication for example, the way the performance of the economy and others, we don't think an approach should be to grow judiciary's budget 5 to 6% on an annual basis, or sometimes even lower than that. In other years, it has been lower than that. We think that the approach that Parliament should take is cases. The main business of the judiciary is to determine cases. How do we fund that determination of cases? And we're giving an example that that even though the judiciary requested in 2020-21, as an example, that 7.4 billion, they only received 17.4 billion, which is an access gap of 53%. At that time, I just want to give context. At that time, there were many stories in the papers about that majority of the budget. I think part of it, 800 million shillings, was going to judiciary procuring vehicles, and most of them were Mercedes, the Max, the Mercedes. And there was a political argument that part of it is that the judiciary is people who are seeking they are not seeking necessities, but rather seeking the luxuries. And that's why we want to reframe the debate by saying that how about we look at the question, the main business of the judiciary, which is making court decisions, solving cases. And then even that's why we are saying that the direction of the budget should be to hire new judicial officers, because if we have case resolution rates, and that case resolution rate would go up automatically. The second question, so to emphasize, the question is now, where should the court access be expanded? It should be at the magistrates court level, because that's where majority of the case backlog is, and a little and on a prorated basis for the Court of Appeal and the High Court. So case resolution for filed and pending cases will remain low, and this is a determination that we've made from previous studies, will remain low below the optimal unless the judicial officers are able to match case supply. Another thing to note, just to tell our audience, is at the magistrates level, the most hardworking judicial officer is the magistrate. In terms of, so if you look at the case average for magistrates, it's around 800 cases per judicial officer. If we look for the others, we look at those numbers for the others, it's very low. So at most, so there are magistrates who are determining more decisions, who are making, who are making, who are working at a faster rate. And then the cost of, so this should be a question of, now this argument should be inbuilt into the MTF resource requirement and stated as a strategic goal. We've looked at the judiciary's resource requests. This is not the case. There needs to be a priority of why, what level of, what cost, how the opportunity cost of not expanding the court access at this level, and what number of judicial officers, when it matches case supply, what it does to case backlog resolution. And we are going to demonstrate empirically in a short while. So, and this is the advocacy point that we are forming. And as we've explained, that's the reason why we are forming that. So there's an efficiency question. So the mismatch between resource needs and allocations has constrained now those judicial officers. Also digitizing court records, expanding physical infrastructure, which are necessary to improve the case disposition rate. So when we did the political economy study, one of the things that we learned is that if the judiciary wanted to resolve all cases, all the 600,000 plus cases that are pending, it will require them to dispose cases at 121% more than what they are doing at present. And if they are to do it within 5 years, they should resolve 21% more cases than they are filed annually. And that has an implication for the resource envelope that Parliament is distributing. And again, one of the things, because we've read the budget policy statement, we've also read which is drafted by National Treasury. We've also read the resource requirement that is submitted by the Chief Registrar of the Judiciary on behalf of the Judicial Service Commission to Parliament for decision. We've read, including other studies that have been done by peers in this field. there's an absence of systematic framework for evaluating cost effectiveness of judicial investments. And we want to make that argument and be able to transmit that to Parliament to tell them that if you provide, you take this direction, if you take this direction, you'd be able to see a return on that investment in this way. Another thing is resources are often distributed without clear evidence of the marginal impact of case backlog reduction. That's a reiteration of the point. So another study, we also did a short study when the previous president had refused to appoint 41 judges, and we estimated that what it reduced the capacity of some of key courts. At that time, it was the higher courts, the Court of Appeal, by denying the system the ability to resolve over 9,000 cases. So we've been able to see that example. Again, in our constitutional framework, Parliament has the powers of the past. If you look at Article 95 of the Constitution, the National Assembly, key decision is to make, one of the key decisions of National Assembly is to decide over appropriations. So Parliament has a dual challenge, which is they have to respond to the constitutional imperative of timely justice. But again, they have to ensure that scarce public funds, because there's a scarcity problem. The reason why we've given that decision to Parliament and not all of us is because there's a scarcity problem. So they need to make a decision on which opportunity costs, which trade-off is better for that. And that's why they have to make a decision that that public funds should yield the most significant possible reduction in case backlogs. That's why, so we are just building a case for why cost effectiveness analysis would be important to compare the cost of, for example, additional judicial officers, as we will demonstrate, digital case management systems, and other interventions. At that, we have to give a caveat here that it's not just case backlogs is not only a question of resources. There are other political economic questions, and we identify them both on the demand side, on court users, and also from the courts. What are the problems on both sides that exacerbate this problem? So capacity is inherently one of them. But we are just saying, and you can go to IES website, you'd be able to read that political economy study. So now we need to apply the cost effectiveness framework. And there's a study, we'll share the link for that study. But here is for you to be able to see our example. So one of the things that what we already have is the emoluments budget, which is the cost of hiring and maintaining judicial officers. And a judicial officer in this case would have, for example, there'll be a registrar of the courts, there'll be court assistants, there'll be the typing pool, people who type all those proceedings, there'll be drivers, there'll be all manner human resource. There'll be everybody who manages the judiciary. So once you have a judge, there are specific other human personnel that you need to provide. And we know the number of cases. We know the number, the emolument budget. We also know the number of cases that they resolved as per the latest data in 23-24. latest available data in the 2023-24 financial year. So for every and the efficiency ratio that we see is that for every Kenya shillings of 1 million that the parliament allocated, 34 cases were resolved. So we already have a bearing on the number on the efficiency question, what is required. The second issue is to now in that 23-24 financial year, how many cases per judicial officer that a judicial officer so, and you find that for every for the 476,137 cases that were resolved, and a total of all the 979 judicial officers over the entire court system, you'd be able to see that that's 486 cases per judicial officer. So just carry along with me those numbers because we are going to show some specific simulations. So another thing is the cost per case is 29,421. It's just breaking up the 1 million shillings number. And to keep one judicial officer, you'd require 14 million, 14.2 million shillings. So that's the framework. Now, so then we ask ourselves, so let's say, for example, I'm sitting at the chair of budget committee, and I want to persuade. This is for example sake, members of my fellow members to vote more for judiciary, and for them to specifically hire additional judicial officers, and what that would mean for the people of Kenya, for the people of Kenya. In terms of case resolution. So if for the next financial year, if you raise the number of judicial staff by 10%, that would move from 979 to 1077. 1077. And that would also raise the compensation compensation budget from 13.92 billion shillings 13.92 billion shillings to 15.31 billion shillings. And if you make an assumption that the case number will around be the same, around the same, that case resolution would raise because of the number of judicial officers, you'd see that they would be able to solve an additional 47,614 cases. And then we're able to do, if we raise an additional by 40%, it will raise the budget by additional 6 billion from the current financial year to 19 billion for compensation of employees. And then that would raise an additional 190,000 cases. And then if you raise it by 80%, which are the 80% and 100% are the most desirable scenarios. In this case, you'd be able to raise it by between 380,000 cases to 476,000 cases. And that would have doubled the capacity that the judiciary requires to resolve cases. So you see that these numbers have a direct policy implication. And this is specifically making an argument that what is being appropriated is not to buy new Mercedes Benz or to go for trainings in very fancy locations or to foreign travel or domestic travel. It's just to hire new judicial officers who would be able to sit again in courts and make case decisions. Then on the other side, we need to see that that caseload, how that changes to caseload. So if you raise by 10%, the new caseload would be 523,751, and 666,592. And if you raise it by 80%, by 100%, it will be at 952,274. And if you compare cases that were filed and pending cases, this in raising the judicial number of judicial staff by 100%, and which is an additional 14 billion for only additional 14 billion shillings, moving the budget from 13.9 billion to 27.8. It would double the capacity of the judiciary and be able to resolve all cases that are required. Obviously, there'll be marginal cost increases for example, courts on the way and the other things. And in the costing, the other study that we done on the costing the consumer mandate of the judiciary, that would require another 40 billion prorated over 5 years. So the case backlog problem essentially is an estimate 60 billion shillings problem. 60 billion problem. And so we provide a small interpretation for just to give guidance. So we are using something we call in economics the constant returns to scale, and between the judicial staffing and case resolution, meaning that each additional staff member will contribute proportionally to the caseload throughput. The second issue is that this assumption is explicitly justified as real-world systems typically experience diminishing returns beyond a certain threshold. And we have an example. So, for example, close to 50% of all cases that are filed are within a geographical location of 11 counties. So a majority of these 11 counties are urban, the Nairobi metropolitan area, some parts in the coast, and some parts in Western Kenya. So you're able to see you'll be able to see that so there's a geographical implication to it. So part of it is there'll be additional outside just hiring those additional judicial officers. There'll be a guidance questions on how some of these resources will be allocated. Again, that we've emphasized issue 3. Issue 4 is that each shilling allocated to judicial staffing predicts a predictable and linear increase in output cases resolved with no evidence of diminishing or increasing marginal returns. The second question is, now, so you can scale up staff without distorting unit costs. And we think that this is the most important, this cost effectiveness analysis is the most important approach that Parliament should be able to use. And then the other important thing without repeating is the main objective, if it's to clear backlogs and also to improve efficiency, staffing increases need to be paired with complementary reforms, which is process automation, so for example, making the e-filing system universal, digitizing court records, improved case management systems. Improved case management systems. It will also changing practice directions. There are other things that need complementary reforms that we outlined in the political economy analysis. Or at every stage, what needs to be done to be able to change this? Because case dynamics also you might have a judicial officer, but there are many other things that determine those case dynamics. So we've provided caveats to this model. So the main aim is to raise the throughput at the magistrates and high court level and the Court of Appeal. Obviously, the Supreme Court, the number is already limited by Constitution. So you'll not be increasing that throughput as much. But now it would be a question of if a magistrate can hear more cases, why is, for example, a Supreme Court justice not being able to have the same level of efficiency? So those are questions that will be raised at public level. Second issue is that so it's a question of productivity scales with linear head count. But we are also providing a caveat to say that, but Parliament need to know that there's the administrative capacity questions and also the infrastructure questions. So at some level, if you had 25% more to the system, you require now more support, and then more support, and then the other thing is, so the direction, not just to add more judges. It's not just to only add more judges, but to also allocate them in an efficient manner. So if 50% of all cases that are filed on an annual basis are within this geographical spread, you have to allocate more judges to those specific areas. So we also calculated years to eliminate backlog by each scenario. And if you raise by 100%, it will take 1.23 years, 80% 1.5 years. Raising by 10% on an annual basis will take 6.5 years. And here we are assuming that filing rates will not change substantially. So fiscal options for financial year 25-26. It's just to So judicial staff expansion is a fiscal neutral way to scale up delivery of justice. There is a value for money argument when MPs provide additional resources that are ring-fenced to hiring judicial officers. Additional proportions for appropriations for judicial staff will also provide for judicial staff will also yield improvements in access to justice with a predictable cost profile. And then there'll be efficiency gains from structural and technological investments, not just more personnel. So we are also giving Parliament a notice here to just say that modern judicial judiciaries in similar comparable jurisdictions, for this case, the case of the Republic of South Africa and the United States, where Kenyan constitution is more comparable to that. I've shown that there is not, you have to increase staffs. You also have to look at rules. You have to look at structures. You have to look at political economic questions, issues like influence peddling. You have to look at integrity questions of those judicial officers. You have to look at, so it's a myriad way. But for the question of allocating more resources, we think that Parliament should follow this guideline and and be able to, and because this is the most fiscally neutral way to scale up delivery of justice. And so we didn't provide a benefit analysis, but looking at case resolutions, especially on the commercial side, there'll be certain improvements in the economy, contract enforcement. So there's big benefits that would come from Parliament in phasing out case backlogs. Thank you so much. I leave at that so that we can begin the question and answer.
That marks the end of our presentation. At this point, I'd like to go straight to the plenary because I think the presentation by Leo was very elaborate and with a lot of details. So we are keen to hear what questions you have on what contributions you'd like to make. So if anyone has a question, we'd like to invite you to, or a comment or any feedback, please raise your hand and we'll allow you to ask whatever question or to make a comment. So do you agree with the findings? Do you have any areas that you'd like to be clarified? Please raise your hand. Yes, Ayodo, I see your hand is already up. Please unmute yourself and let's hear your comment.
Yes, one comment I have is in relation to judiciary having a strategic plan. It is my expectation that that strategic plan should focus on future resource needs and how they are going to mobilize. So if the team looked at it, they tell us something about it. Two, there is the issue of performance management of the staff. And I think from HR perspective, it is not just about increasing numbers and budgets, but the question is, what is the current performance of what is the performance of the current staff in relation to set standard? And there was talk of optimal. It is understood that when you say below optimal, then there's a standard that sets the optimal. So if we are looking at numbers and how they are performing, that would be of interest. The other question or comment I have is, as we talk about numbers, what is the degree of automation in the judicial processes? Are we at 40, 30, 60? Because then that also determines the kind of work method that is being used. Are we using more manual? Are we using more automated? Because in HR practice, the more automation you go, the less numbers you would require. But my other issue that contestation I have is on the issue. The backlog is a temporary issue. So if we hire permanent staff based on the backlog, then we are going to arrive at a situation of idle capacity. And my last comment is on what I would call one thing that is not clear is whether these backlogs are criminal cases or civil. That would be of interest. But I assume because they are magistrate cases, majority of them are criminal. It will be useful going forward as an institute to look at the whole concept of the criminal justice system and the court users. How do they contribute to this backlog? Because then adding resources at the tail end, which is the judiciary, and not addressing the source, the root cause. And the root cause here means, for example, youth and the children's services, because for criminal, that is the biggest source. Thank you.
Thank you. Thanks a lot, Ayodo. Very important questions. We will be responding shortly. I see another hand. Just a second. Yes, Linda. I see a hand by Eunice. Eunice, could you unmute yourself and let's hear your question?
Yeah, hi. Thank you so much for the presentation. Very relevant, and I think also for me, it reminded me of my days in practice. I have a few points. And thank you, Ayodo. You've actually mentioned the issue on digitization. Anyway, so the digital side of things. I think when you're making your recommendations, I think it would also be good for us to think about the use of AI. We are in that time, we're in that period where, because from what I remember and how practice went was there were some courts where hearings were already recorded and then transcribed. And then there are the ones where, it's pure manual and the magistrate literally has to write everything. So you see, once with the AI that we have right now, adoption of that can be able to, at some point, reduce that manual fatigue of having to write and then go back, transcribe. Go through everything, if you understand what I mean. So
Yes.
yeah, the digitization actually as one of the contributions and adoption, of course, ethical adoption of AI for the magistrates so that we do not forget to actually use our minds. Then I have a question now on I got lost at some point on the calculations, but I got the idea. So the idea was how much it may cost for us to get a number of judicial officers added onto the current existing human resource capacity of the judiciary. And just wondering, what is the proposal? Like, what is the achievable right now and affordable amount or number of magistrates, judicial officers that we can comfortably recommend to Parliament and say, if you get this, it will not, weigh heavily on the wage bill, and it is purely and clearly achievable. I'm so curious to know how much that would be. And then when we're thinking about that, thinking we're hiring new JOs, but hiring new JOs is good. Then, by the time you're hiring a new JO, before the JO understands, the digital officer understands the process, understands how to properly carry out or arbitrate cases. That we need to also keep at the back of our minds the fact that you have to consider the time, the training it will take for them to become able to give good quality rulings, good quality judgments, and to arbitrate properly. That usually would take time, say like even up to a year or so before they get good enough for us to say that now we are getting effective arbitration of cases. So that's a part also to at the back of our minds. Yeah, thank you.
Thanks, Eunice. So very useful contributions. We are taking note of that. So then I see a question in the chat box. SKM says, have you considered a situation where alternative resolution mechanisms such as mediation, negotiation are enhanced? So not necessarily by judicial staff. So that's his question. So before we allow any other oral verbal questions, I'll invite you to go first. You can respond that with Ayodo's question. He had a few here.
Yes. So I think the question on automation and automation is a running question between Ayodo and also Linda. But the big question is we've tried to study what areas automation needs to be changed. And for me, I think it has to be a conceptualization problem, because you see, like, some judges do not want advocates and litigants to record court sessions, but to record court sessions. So it's a question of how fast can you move on the transcription, because there are transcriptions that are almost accurate, and then the question, it turns now the typing pool team into for them to verify, to hear those transcripts and be able to verify, which makes those faster, because in some regions, for example, typed proceedings, which are very essential to moving forward with with resolution of decisions. So the automation part has many angles, and that's a point that I want to make. And our proposal is that at every stage, from the filing stage all the way to when the arguments are being added, to judgment being delivered, it requires a rethinking from what is being done today. In other places, in other jurisdictions, so for example, judges would require that submissions not more or less than pleadings not more or less than certain number of pages. Those are questions that need to be discussed. That need to be discussed on what needs to be done for. So I've given automation and we've provided it as part of the recommendations, but it has to be a problem-driven approach in how automation is deployed. The second question, the strategic plan, we think IODO and we as the Constitution Law and Economy Program, we want to support more of constitutional mechanisms. And we think a strategic plan for the judiciary should not be the case. We think that all the questions, the Constitution and Parliament has provided a way in which they should approach the question. So like the State of Judiciary Annual Report should have a chapter focusing entirely on the question of resource questions, on the question of resources, for example, problems that affect judiciary. I know at the moment it's a question of it's a different issue altogether, but that State of Judicial Annual Report was to provide a basis in which some of those contextual issues that affect judiciary to be discussed in the executive, because by other arms of government, especially in this case, question of parliament. So we would not like to promote the strategic plan, because that strategic plan reflects from our political economy and organizations' specific interests. So, for example, you'll find other people making an argument that the car and mortgage scheme in specific institutions in government be doubled, or you'll see institutional interests rather than public interest questions. So we think that a larger part of that, that those questions should come. If there is an issue, it should be raised through the law, the constitution and law mechanism. I also disagree, Ayodo, on the question that backlog is temporary. It's not. It's a flow problem that accumulates to a stock problem. Flow in economics is so like today. If you go and file a case, matters that were had in this month, judgment should be coming in between February and May of next year. And matters that are filed this year, you are looking at earlier date of June and that kind of the thing. So it's a moving average. So you'd find a way that because the current cases have already filed this year and towards the late of this year, already have a larger part of next year. Remember that. So let me give an example. There are close to 700,000 by end of this year, an estimation from our side, given the numbers that we've seen for since 2018. That 700,000 number of pending cases, majority of those cases have already occupied, are already factored into next year's calendar dates. So that what the judiciary would be doing next year is to designate specific judges to take that they are taking dates for the future years, the 2027. So you see that it's not a temporary problem. there has to be a cut-off date. And that's the emphasis of why we're telling Parliament that you have to recruit more at these three court levels, the magistrate, the Court of Appeal, and the High Court, so that you have a cut-off date and say, we want to have this problem done once and for all. But as it is, it's not a temporary problem. I've looked at the data, the statistical abstracts, as far as 2003. It was worse even at that time. Some investments have been made in the right direction post 2010, but I can tell you that it's not a temporary problem. So those are the way the flow problems happen. If you are taking, you have 700,000, they have the capacity to resolve 400K. The pending cases are like 700. If you had the filing rates for that year, what will be filed in that year, it's close to 1 million. It's close to 1 million. Then they will go and resolve that 500,000. So you'll see those more cases piling up. So that's the question that that backlogs are temporary. And again, there is an SRC. That's then those cases, and then a human resource, as you said, a human resource measure should come into place. On the question of use of AI, of artificial intelligence, on the question of the use of artificial intelligence and the ethical adoption of AI, it's now where? It's a question of where. Because at this stage, it should be, if all those sessions are recorded, and then a transcript is clear. So that's the thing that I've answered when in the first question that these are problems that the judiciary should in terms of should convene. But for us, we already see the use, especially not most people think about generative AI, but even the non-generative AI, like the machine learning and others could have a bigger role in the way those transcripts are present. In terms of what is achievable, we've provided scenarios. We have to provide those scenarios because we think that the most optimum is when the capacity is doubled by 80 to 100%. We also have to provide scenarios to show that we've provided those scenarios, but at the moment, at 10%, at 40%, or 30% more of judicial staff, advancing judicial staff, would provide, but the outcomes would not be far-reaching and more consequential and more distributional than the others. So we have to give them scenarios for them to be able to see. They'll be able to make a decision on what is more important, but those scenarios have to be provided because, especially because we are seeing impact. And the question of time, just like, so it's a question of recruiting and also allocation. So it's for them to catch up, they'll catch up, and then the subsequent financial year will be able to see those benefits. All in all. On the SKM question, alternative resolution mechanisms, we are looking at Article 159, and people who are in court. We can have that as part of the model, but we think primarily, and given the way a more liberal interpretation of the Constitution of Kenya, is that that should be matters should be decided in in court primarily. And then if there are no, if people opt not to go to court, then AJS can be complementary. But we are not treating that court access as a substitute. That court access as a substitute, it doesn't. It doesn't. So it should be complementary, but court access should not be substituted with anything else, because we've seen adverse problems with these AJS, especially in the criminal. Oh, on the distribution, I order before I forget. Civil criminal is almost similar. Civil being IA and some years, but it's almost there is no big difference in those cases. Thank you.
Thanks, Leo, for those responses. I'll just add a few things because you've responded to almost all the questions. So I would agree with Leo on the question of the temporary, because Ayodo had stated that he thinks the backlog issue is temporary, and so hiring the challenge with hiring additional officers over time. What happens once the question is resolved? And so I just agree with Leo here that it is true that the case backlog has accumulated over time, but as we saw in the numbers, it's mostly because the number of filings has continued to outpace the system's capacity to resolve the cases. However, the thing I'd add here, and I think Leo has also mentioned, is the underlying causes that have exacerbated this problem are structural. And so even after the backlog is cleared, as we have seen in the numbers, the inflow of the cases will continue. The inflow of new cases will continue. And so if we don't address the capacity problems and efficiency simultaneously, then we'll simply find ourselves back in the same situation in a few years. So we might need to think strategically about the deployment. Of course, Leo has illustrated here that the bulk of the cases is at the lower courts. Also, then the judiciary should think strategically about the deployment, what areas would require the most officers. So even within the magistrates' courts, where exactly should the investment be heaviest? And so basically pairing that strategic investment with other forms of reforms like automation, the AI deployment as has been suggested, and so on. But the backlog problem, what we are stating is we do not think it's a temporary problem that will be resolved in 5 years and that's it, it's done. So that's the only thing I'd add to that, the feedback from Ayodo. And then Linda, on adoption of ethical AI adoption, I absolutely agree with you. I think it's something that would be very timely, and it's a strategic recommendation in the judiciary context. So because we know, again, the number of things that contributes highly to the case backlog is mostly this administrative, small administrative tasks, the clerical tasks, document reviews, case tracking, cause list management, and so on. And so if they apply AI responsibly, I think it would help to free up a lot of the judicial officers' time. So they can do things like automating the things that are routine, like case classification, and just generating standard rulings and summaries for some of those very technical, routine things like traffic offenses and so on. So this would help to free up the judicial officers' time. But I liked that you added the question of ethical use of AI, because again, as we know, the question of administration of justice specifically should not ever, we should never have AI replacing the human judgment, because that would compromise due process of the law. So yes, adoption of ethical AI, I agree with you, should be a recommendation. So I don't know if there's, yeah, so the only other thing that I wanted to respond to was on your question of whether we've considered the onboarding time for new judicial officers and what it means. So yes, it's true that like for any other position or any other job, onboarding of the new judicial officers would take time. And as you've mentioned rightly, a newly appointed magistrate or judge would require several months, which is all very true, even a year. But we have not assumed that we expect an immediate outcome in resolution of these cases. So from a cost effectiveness perspective, because remember our analysis is from a CA perspective, so the time lag, that little time lag would not invalidate the investment that has been made. It would simply means that some of the results might be slightly delayed, but not that it's invalidated for that full year of onboarding them. So once the officers are fully inducted, then of course we'd see the system responding with higher productivity and higher resolution of cases. So the practical way or the practical takeaway would be sort of having that and having it in a phased the phased recruitment plan. So thank you all so much for your engaging questions and useful feedback. And I'd like to welcome a few more before we close this, maybe one or two more if anyone still has a question that you'd like to ask verbally. I see a few more on the chat box. So Hussein says, can we attach a judicial officer promotion to his or her performance on the number of effective cases attendance and deliveries based on weighted scales? So that's the question of performance management. And then Vincent Tanui says, this has been insightful. Assuming that the majority of cases filed at the lower court will eventually end up at the apex court, and considering the structural composition of the Supreme Court, what will be the implications? Based on the premise of cost effectiveness, would this necessitate altering the composition of Supreme Court judges? So we've noted that. And then SK says, Leo, true, this ADR is to boost the speed with which cases are resolved, and 159.2 foresees the use of this mechanism in order to ease pressure in courts. Okay, so I think that's a comment, but I think Leo had already clarified that our specific focus here was on the dispensation of justice through the court system, not the ADR, even though it's also prescribed as an alternative. So Leo, would you like to respond to Vincent and Hussein before we close? Because I don't see any other hand up.
Yes. I just want to add an anecdote. A few weeks ago, there was a decision from the Court of Appeal, and that decision was on intellectual property application, and it cited an act called Geographical Indications Act 2019. In Kenya, we don't have a Geographical Indications Act. Actually, the geographical indications argument in intellectual property is supported by the trademark law, I think, which was passed around 2001. So ethical use of AI is an important policy question for judiciary, because that was clearly, and it also exposed many things about how judgments are written in the are written in court in courts. So just to add an anecdote to that. So Vincent, the composition of where no, it won't need to alter the composition of the Supreme Court. It requires the Supreme Court to to year cases. Supreme Court has a case backlog, I think, less than 2 years, and it's either moving between 60 to 80 cases. So it should not necessary deal with the Supreme Court. The big issue is to get the burden off at the lower courts, which is now and the subsequent appellate courts, which is for them to be able to hear all cases. Case is filed in January and has to be concluded before. By the case backlog definition in the Kenyan standard is a case has to be heard within and determined within a year. Yes, SKM. That's a very important argument, and that's a very, very important distinction. And court access, it's a complementary. It's complementary. It's not a substitute, and that's why. And we even seen a reverse trend by the because like succession cases, contestations, for example, where even what is contested is very, very small. It is a small. More of them are being filed in court than them going through mediation. You'd find that cases that are ideally supposed to go through mediation are not. And then you find that others, like criminal offenses related to sexual offenses, and others, defilement and others, which are not ideally supposed to go to mediation, are going. So you're seeing that reverse trend, that cases you'd expect, commercial cases, tax issues, that do not require interpretation of law, but an assessment, independent audits to determine assessments and more of them are going to courts. So you find that issues you'd ideally expect them to go to court, not to go to court, are going to court more than the ones that are. So that reverse trend is something that I would. So that's the question from Vincent, and so Jackie, back to you.
Thanks, Leo. There's one last one. Leo, there's one last question on how would applying the cost effectiveness analysis specifically change how Parliament allocates the judiciary's budget? So shifting the focus from what inputs are funded to what outcomes are achieved. Because I can't seem to get Ayodo clearly. Maybe you can answer this as you make your closing remarks.
Cost effectiveness analysis change how Parliament allocates judiciary's shifting focus from what inputs are funded to what outcomes are achieved. So Kenya follows what we call the program-based budget framework, which is it's a program, their outputs, their outputs, their inputs, their outputs, and then their specific outcomes, and then what is allocated, and even the definitional question of what problem is being solved. So if you look at the program budgets book, the PBP, which is also followed by by executive, the judiciary and parliament. If you look at that resource request, it follows the PBP mechanism. So for us, the idea is it's to provide a trade-off analysis. So if you had, for example, the way Parliament would receive budgets, they would receive budgets that are, this would be what the judiciary wants to do for personal emoluments, the number of staff they want to hire. There would be a vote on vehicles, on use of goods and services. It will include vehicles. There will be other things, including domestic travel, foreign travel. It will include communication, like a lot of things. There will be many other budget items. So the question now for Parliament, and they've made this decision many times, is to ask what value would it give to the people of Kenya if, for example, instead of giving $1 billion shillings to buy vehicles, to give that $1 billion shillings to hire more judges and judges and magistrates. That would be, so it makes that argument, and it provides a distinction, because if you look at this map that we provided, there'd be no other argument that could be able to beat that cost effectiveness. So when Parliament receives budgets, this can be a yardstick to determine what kind of decisions that are expected into the future. So I've seen last question whether Kenyans are getting more litigative in the past years than in years past, or asked another way, do you expect that cases of courts would continue to pile up? Yes. So I don't think Kenyans are getting more litigative. I'd prepare a chart and now take the cases filed on an annual basis and now adjust it with population. You will see that there's no much bigger difference. There's no much bigger difference if you adjust those cases filed with population. But what we are seeing is that as the population continues until 2045, when we start to get that demographic dividend, when Kenyan population would be 80 million or more, you'd still see these numbers go up. So that 2045, when the demographic dividend would be present, you'd start to see those numbers going. So those numbers plateau or start to go down. But from now until then, you still see more. You still see the number of cases grow because of population, the proportional question. So just to end with that, we are the Constitution, Law and Economy program. We'll continue to study questions within the justice sector. We've looked in the previous time, we had looked at another question we had looked at in the criminal justice system is a question of what the ankle bracelets as a solution to the bail and bonds issue. We still continue to study more questions, including what kind of the reform on the penal code and other things. So we'll please be on the lookout for this. Those were very inquisitive questions and would shape future researches around this area. Thank you so much.
Thanks a lot, Leo. And thanks a lot to everyone that has contributed in terms of asking the very valuable, useful questions you have. Momanyi, your question, which Leo has already responded to, is a perfect place to end this discussion, where you were asking how would applying a cost effectiveness analysis specifically change how Parliament allocates the judiciary's budget. So shifting the focus from what inputs are funded to what outcomes are achieved. So I think it's a great question because it actually captures the essence of the discussion we're having today. So what makes cost effectiveness analysis a transformative tool for budgeting? So as you already know, and Leo has mentioned, Parliament allocates all resources, the judiciary is included, by focusing on inputs. So for instance, how many court buildings do we need? What of this do we need? How much do we spend on operations? Which is all these are legitimate questions, but then they don't tell us what impact traditionally that spending actually achieves. So our innovative proposal here would be to strike a balance, and this would also be helpful for the judiciary itself if they can demonstrate how the additional resources will go to yielding better outcomes for the institution. So because the cost effectiveness analysis would flip the traditional inputs funding approach and instead ask, so for every additional shilling that is allocated, how many more cases are resolved? How much faster is justice delivered or administered? So if the judiciary can show this as part of their justification to Parliament, rather than just the funding of activities, then Parliament would be moving towards funding of results as opposed to funding of activities. So that's essentially what we are saying in our proposal, in our findings here, that there's need to consider the outcome-based approach that would encourage the performance-oriented budgeting. So with that stated, I'd like to thank my colleague Leo for preparing this presentation and for making it here as with me. And I'd also like to thank all of you who've sat in for the duration of this webinar. Thanks a lot for your contributions. We hope this has been useful. We will share the presentation will be online, will be on IE's website in the next few minutes, if it's not already there. And we also have a paper. So this study is in the form of a paper that is currently going through design and layout and will be published. So if you'd like to read the full paper, please visit IE's website and you'll be able to access this and other IE publications. Then lastly, the IE is a membership institution. So for those of you who are here and you're not members and you'd like to be, please get in touch with our communications team. They'll be able to assist. They can provide assistance on how you can join and what benefits you'd get from being a member. So thanks everyone. Please be on the lookout for other IEA discussions on our social media platforms. You can follow us on Twitter and you'll be apprised of any upcoming events. And yes,